Hey, and welcome to our monthly managerial tuition. Today we're going to do on the important aspect of your managerial responsibilities around disciplinary management and disciplinary actions, because they can be really challenging, but with the right approach you can create a positive work environment whilst addressing the conduct issues that might arise within your team. So let's dive into some of the key process points that our clients have been struggling with a view to alleviate that challenge and struggle for yourself. So the first stage of this is the investigation. Most managers get that and we're pretty comfortable with it. But effectively, an allegation is brought to the attention of the line manager or the employer, and you as the employer then need to conduct a thorough investigation, gathering all of the relevant facts and evidence. It might involve some interviews with the employee in question and potentially any witnesses, as well as any other relevant data, reviewing policies, etc. And then if the investigation reveals sufficient evidence to proceed, a disciplinary meeting should be scheduled. But importantly, and this is where our managers struggle, this has to be a different person. The disciplinary manager cannot be the same person as the investigation manager. And there does need to be an investigation and materials presented to then give to the disciplining manager and give to the employee prior to the meeting happening. Those are key critical stages that a lot of our clients are struggling with. The disciplinary hearing itself is then conducted with a different manager, allowing the employee to state their case, respond to any allegations or concern. They've got an opportunity to present evidence. They can call witnesses themselves, they can ask questions, and you as the employer can review all of the data as the disciplining manager, including any evidence, witnesses or testimonials. The next point is around decision and potential disciplinary action. The next myth to bust is that you have to have beyond reasonable doubt evidence prior to making a decision. That is criminal law, which is fundamentally different to employment law. Employment law is something called the balance of probabilities. Now imagine this is a scale. If it's like that, then you can't make a decision. But if there is material information and evidence which switches the scale like this to actually, on balance, it is likely that this individual did do this, and there is broadly evidence to support that, albeit there is a few elements of evidence that doesn't quite stack up, but on balance, this is what happened. At that point, you should and can be making a decision. Importantly, you should, for the good of your culture and the good of your organisation. And don't forget, the rest of your company and your talent is watching you. So after you've done that, and you've considered all of the facts, assuming that there is a case to answer, possible outcomes might include a verbal warning, a written warning, a final written warning, or if the case is such a serious nature, could be a dismissal with or without notice. So the severity of the sanction depends on the severity of the issue and as employees' previous conduct and their performance history and all those sorts of things. The employee then has a right of appeal, and they can do this. The employee, if they're dissatisfied with the outcome, they've got the right to appeal. The appeal should be made in writing, stating their grounds for appeal. And the appeal should then be heard by a further different manager, typically more senior, or an independent person such as HR download to that who is involved in the process. At the appeal meeting or appeal hearing, it allows the employee to state and present their reason for their grounds of appeal and any supporting evidence that they want the appeal manager to review. It's important that the previous case notes from the investigation and from the disciplinary hearing are also given to the appeal manager so that they can review the whole case in its entirety. And the decision's then made, and at that point, the decision from the company perspective is final, and it concludes the disciplinary process. So I hope that makes sense. There are a few myth-busting issues in there that should support you and your team if it is that you have an issue arising. When you have an issue arising, please make sure you call us at HR Download on our advice line, or email into the advice inbox to make sure that we can hold your hand at every single step of the process. Please don't leave halfway through the investigation prior to calling us. We will help you strategize the investigation, help you understand where the evidence is coming from, help you understand, importantly, where the balance of probability is broadly sitting for you, and enable you to really get to grips with confidence of that very, very challenging process. Thanks ever so much, and bye for now.